The First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case scheduled for oral argument this morning, the case of CM versus the state of Florida. We've allocated 15 minutes per side for the oral argument. Counsel, you may approach. Counsel, would you like to reserve some time for rebuttal?
Yes, Your Honor. I would ask to reserve 5 minutes of time.
So noted, Madam Clerk. You may continue.
May it please the court, my name is Tyler Payne, and I represent the defendant in this case. Now, this case is about the fact that the legislature has changed the law, and now the rule should change to follow the law. The rule made sense. The rule that per se probable cause based on an officer's mere observation of suspected illegal cannabis, that made sense when there was a blanket prohibition, because the officer could recognize the substance that he's been trained to recognize, he's recognized before, and by a fair probability could say this is contraband rather than some other lawful substance. However, now the legislature has changed the law, and now we have 3 substances, all of which are indistinguishable by an individual officer, and 2 of these substances are legal in Florida. So now we're asking the court to reevaluate this rule because the basis for the rule is no longer valid under the law.
Counsel, why don't you give us a little factual background in this case?
On this case, Your Honor, yes. My client was pulled over for speeding, and the officer he described him as being visibly nervous and saw a baggie coming out of his pocket of a green leafy substance, and also smelled the odor of what he suspected to be illegal cannabis at the time. And he asked my client to come out of the car and search this person, finding some contraband items.
When was the first unlawful act by the deputy? What did he first do illegal that would start the fruit of the poisonous tree?
Well, my argument would be when he pulled him out of the car and searched this person. That was when the search was initiated, and I would argue that the officer needed probable cause to start that search right then and there.
Well, he can lawfully ask a driver to step out of the car during a stop. It was when he went into the pockets and then satchel that would be the issue.
That's correct, Your Honor. That would be our argument.
Why wouldn't there be reasonable suspicion for a Terry frisk at that point?
Well, under Terry frisk, you need reasonable suspicion the person is armed and dangerous, and prior to patting down my client, there was really nothing to show that my client was armed or dangerous. He was very compliant, apparently very polite to the officer, it seems. So there was no reason to suspect that he was armed at all before the search. So we would argue there's no reasonable suspicion based on all the case law we talk about dealing with potential contraband items.
Were there any other surrounding circumstances other than the smell of marijuana and the package he saw in Helen's pocket?
Were there any other
Surrounding circumstances?
as far as contributing to possible probable cause, Your Honor?
That is correct.
I understand. Well, I suppose that he was nervous. I think that would be a contributing factor to factor in. But beyond that, Your Honor, essentially it was just the fact that he observed my client with a substance that he thought was illegal contraband. And so this case presents really a clear question of law as to whether there is probable cause based on that mere observation. And we would argue there is not, because if you look at the body of case law dealing with other potential contraband items, I think it's quite clear that just the fact that something may be contraband is not sufficient. There needs to be some indicia of criminality showing that this is in fact contraband.
Counsel, the trial court relied in part on this court's opinion in Johnson versus State. Can you distinguish Johnson?
Yes, Your Honor. I believe Johnson's very distinguishable, and as I point out, at great length in the initial brief, the basis for Johnson's reasoning, I think, was valid at the time, but the law has since changed. Especially
What are the changes? What were the changes in the law since Johnson?
Since Johnson, Your Honor, we have a change in the medical marijuana statute allowing the smoking of medical marijuana, which was prohibited at the time in Johnson. But we also, more importantly, I think, have the total decriminalization and removal of, as a controlled substance, hemp. And that really, I think, changes the equation in a way that Johnson did not foresee at the time.
Is the only difference between hemp and illegal marijuana the THC concentration in the plant material?
Yes, Your Honor, that's correct. As the state stipulated below, these are substances that are indistinguishable by sight, smell, or touch, but one is illegal and one is legal. So
We have, I guess not record evidence, but you made mention to a public source of the number of licensed medical marijuana users in the state. We don't have any record evidence or any statistics on the number of hemp users, right? Is that correct?
yes, Your Honor, that's correct. The legislature did not see fit to make any sort of licensing or accounting sort of statistics when it removed hemp from a controlled substance. So we really don't know how much hemp is out there, how many people are buying them. I can't really answer that question for this court, unfortunately. But essentially, I'm asking this court to set aside the stigma associated with cannabis. I understand it's a stigma that we all kind of, I think, inherently carry. But really, if the legislature had decided to say one day, we're going to make watermelons with seeds a controlled substance, you cannot own those. But at the same time, we can have watermelons that are seedless. That's perfectly legal to buy at any store. Would an officer have probable cause upon seeing a watermelon to take it and crack it open to see if it has seeds or not? I think the Fourth Amendment is quite clear in other contexts that an officer cannot do that. He needs.
What about federal law? Well, marijuana remains a controlled substance under federal law, correct?
That is correct. However, the federal legislature has deemed hemp to be different from cannabis now in the same way that Florida has. And so hemp is perfectly legal under both Florida law and federal law, Your Honor. And really, one thing also I want to impress upon this court is that a ruling in our favor would not be a sea change, undoing all marijuana precedent. Really, it would affect a very narrow class of cases. Really, I can think of two examples. And this is all under the background of cases where it is mere observation being the predicate reason for the search. So other cases where there might be somebody fleeing or giving false names to officers, false information, high crime areas. Those are the factors certainly can come into play in other cases.
Well, what about, first he did smell it initially, correct?
Correct.
Okay, so then he sees the baggie,
Correct.
but then your client was very nervous, right? Or at least that's the testimony.
Yes, that's the testimony, Your Honor. That he was,
So nervousness plus the smell does not equate to probable cause in your view?
in my view, no, Your Honor, it would not.
Why not?
And that's because if you look at other cases.
Why would you be nervous if you're possessing a legal product?
Well, oftentimes people have social anxieties and things like that. People can be nervous for many other reasons other than having, a lawful or an unlawful substance in their possession, certainly. And I don't think someone just being nervous would avail themselves of their Fourth
But I
Amendment
mean, the
rights.
probable cause standard is pretty low, right? It's more likely than not.
Yes, Your Honor, the fair probability. But the question is, in my watermelon example, if somebody has a watermelon and they're also nervous, is that sufficient? I would argue it's not. And if you look at the cases dealing with pills and other contexts, there are other factors that could contribute to probable cause. Somebody carrying a baggie of pills in a Ziploc bag or just a single solitary pill in their pocket. Maybe they were nervous doing that, certainly. Perhaps that's an unusual activity, but I don't think that's enough for probable cause, even combined with the mere possibility we may have contraband.
Well, so it's possible that the smell was illegal
Yes, Your Honor,
cannabis, right?
it's possible.
And then plus the nervousness, you don't think that gets to more likely than not? The two factors combined?
No, Your Honor, I would argue that's not enough.
What would be enough in your view?
What would be
He
enough?
would have to give a false name, or he would have to tell the officer, hey, I'm carrying illegal marijuana. I don't quite see your argument as to what is enough.
I understand, Your Honor. And I think it helps to look at what an officer can do in our view under the
I
law.
mean, your brief relied heavily on our case involving the person that had the knife, and we said, I was on that panel, that with so many people in Florida legally owning a concealed carry license, that was not sufficient.
Yes, Your Honor.
You want to discuss that case?
Yes, I think Kilburn is very clear that a potentially lawful activity cannot be the sole basis for a detention. And here we have a potentially lawful activity of possibly possessing hemp.
And am I reading Kilbourne right that there approximately 85% of people would have been engaged in unlawful activity by the number of licenses, maybe some more that didn't need to have licenses, but some large percentage, over 50% there at least, were unlawfully likely to be carrying, correct?
Yes, if you're going by the numbers, just an officer observing somebody with a firearm, it's a substantial possibility that the person is illegally carrying a firearm.
So at least reading into Kilbourne, we said just more than a 50% chance even is not enough for probable cause there.
Correct, Your Honor.
Is that correct?
Yes, Your Honor. That's my understanding.
Is there anything in the record that, come to find out the driver was a juvenile, is there anything in the record that his age was a factor in the seizure or the search?
No, Your Honor, I don't believe it was a factor really, at least not articulated by the officer, that he was concerned about my client being a juvenile and in relation to the charges. And if Your Honors have no further questions, I see I am going into my rebuttal time.
Before you sit down, counsel, can you distinguish the Second District's opinion in Owens versus State? There, the court noted, accordingly, we conclude that the recent legalization of hemp and under certain circumstances marijuana does not serve as a sea change, undoing existing precedent. And we hold that regardless of whether the smell of marijuana is indistinguishable from that of hemp, the smell of marijuana emanating from a vehicle continues to provide probable cause for a warrantless search of the vehicle. Can you distinguish that case from the facts of this case?
Yes,
If
Your
not,
Honor.
must we declare a conflict with the Second District in order to reverse the trial court?
Yes, Your Honor. I believe, this is factually distinguishable factors here with relating to my client, not driving under the influence here, where there was a situation in Owens, as Owens discussed in Johnson. But I think with respect to the Second District Court, I think they did not evaluate this issue with other potential contraband items and all that jurisprudence in mind. I think if you view the entirety of probable cause with potential contraband, as a whole, I think the outcome is different than if you look just only exclusively at cannabis jurisprudence as it has been, for the past few decades. But I would argue against the ruling here, if it goes in favor of my client being a sea change, really would only affect two cases. Cases where the search is premature and it could be a legal item or an illegal item, and there's really no indication based on the facts which it could be. I think that's the situation here. The second situation would be cases where the person says, I do not have contraband, I do not have medical marijuana, I have hemp, but I also do not consent to the officer testing the hemp. Those are really the only two cases that would be affected by a favorable ruling for my client. So it would not be a sea change undoing all marijuana precedent and really, causing an upset in the law, I think. Because very simple questions the officer could ask could really obviate a lot of the Fourth Amendment concerns here. I don't mention it in the briefs, but the medical marijuana statute requires that if an officer asks, do you have a medical marijuana card? May I see it? The person must present that card under penalty of a second-degree misdemeanor. And so probable cause can develop very easily from an officer simply asking, do you have any contraband, medical marijuana, or hemp? And certainly an individual can consent to testing of hemp. I believe they actually have field tests nowadays that can differentiate based on THC level. So probable cause can develop based on if the person consents to testing or not. But if I have no further questions, Your Honor, I would reserve the remainder of my time for rebuttal.
Thank you, counsel.
Good morning, and may it please the court. My name is Ben Hoffman, and I represent the state. I'd be remiss if I didn't begin my argument this morning by talking about what the actual facts of this case are, because as much as the other side continues to push this court to issue a ruling on the question of whether the smell alone of marijuana continues to provide probable cause after the legalization of hemp, the fact of the matter is we're not dealing with the smell of marijuana alone. We're dealing with an officer who smelled marijuana. He smelled it, saw it, and then saw obvious signs of nervousness. And it's not even just a generic case where the officer just testifies he appeared nervous to me. This officer actually was pretty detailed in how he described that nervousness. So I'm referring to page 165 of the record. he says physically nervous, and then elaborates, and I'm quoting, visibly shaking, couldn't articulate his words very well, and then he would actually later go on to say that the defendant wasn't even speaking in full sentences. Reached for his motor skills declined to the point that he reached for his glove box several times, which was within arm's reach, and couldn't get the latch. Avoided eye contact, and the avoiding eye contact is on page 211. And then during cross-examination, even said that this defendant's hands were shaking. So we have smelling marijuana, seeing marijuana sticking out of the pocket, and then seeing nervousness as the officer just articulated. If that's not probable cause, I really don't know.
Am I correct, our case law and other courts, just nervousness alone, I mean, I know we look at the totality of the circumstances, right? But nervousness singularly is not enough for probable cause. It may provide reasonable suspicion to allow the officer to continue to investigate, but standing alone, somebody's nervous, the cop can't arrest him.
Right.
Right. But so you're saying it's a factor in determining probable cause. You're not saying that the guy's nervous so he can be arrested. Is that
Right.
correct?
I'm not saying you can arrest him just because he's nervous.
Okay, but you are saying, though, that the factors here were such that as opposed to pulling him out of the car and continuing the investigation, at that point, the smell, the baggie, the nervousness, the officer could have said you're under arrest. Is that correct?
I want to make sure I understand the question.
Sure,
You're asking,
sure.
could he arrest him based on smelling it, seeing it, plus the nervousness?
Correct.
In a technical sense, I think the answer is yes, because there is case law.
I mean, isn't probable cause the same? You're arguing the automobile exception to the warrant requirement that says if there's probable cause, an officer can search the vehicle, right?
That's right.
So probable cause is probable cause. It's either probable cause to search or probable cause to seize, right? So if the officer could search at that point, the officer could arrest at that point, correct?
He could, and there is case law. It's not in the brief, so I have to supplement. There is at least one case out there that I can think of that does hold that just smelling it, if you had the probable cause based on the smell to search, you had the probable cause to arrest him. I'm paraphrasing. Typically what happens is you field test it, though. Just in all candor, that's over 99% of the time that's what happens is they'll seize it, they'll field test it, they won't actually arrest you until they get a result from that field test.
But as I understand it, the field test, at least at the time, was not able to differentiate him from illegal marijuana. Is that correct?
That's, at the time, yes, and I think the parties
Who
stipulated to
knows?
that, so I'm stuck with that either way.
Sure, I understand.
But yeah, so nervous behavior, smelling it, seeing it, that's factually what we have, that is probable cause. I will address the issue of obviously just smelling it alone, since obviously that was extensively briefed, and that was an alternative basis for the trial judge's ruling. He ruled in the first instance, the totality of the circumstances provided it, and then he went on to elaborate, smelling it alone was enough. So I do want to address that question. And I think really what this case boils down to, or really what the dispute boils down to, is the level of certainty that an officer has to have before we can say he has probable cause. Probable cause has been articulated differently, including by the U.S. Supreme Court from case to case. There is one articulation I do want to note that I think actually does speak to this dispute, and that is the Supreme Court's definition of probable cause from Texas versus Brown. I'll supplement with it because that definition is not in my brief. But in Brown, the Supreme Court gave the familiar first part of the definition, that probable cause requires circumstances that would warrant a person of reasonable caution in the belief that evidence of a crime will be found. And then it went on to elaborate, and I'm specifically quoting now, it does not demand any showing that such a belief be correct or more likely true than false. And that is from the Brown decision. So it's our position that regardless of whether an officer can distinguish marijuana just based on smelling it, or in this case, seeing it and smelling it, that does not mean he doesn't have probable cause. It's not the state's burden to show even that it's more likely true than not. We only have to show that it's a fair probability that criminal activity is occurring.
But we can't decide this case on that basis, right? Because
sorry?
we have the other factors.
You do, and that's why I started with that,
Right.
Judge Thomas.
That would be pure dicta to make a ruling based on smell alone.
It would be. That's why I started with, the facts of this
understand.
case are, exactly. But I know it's It's a
One day
question
it
that
might happen.
it's a question we're all itching to get to, so
Right.
so I felt the need to at least address it partially. But I do want to turn to some of the case law, and I guess I'll start with Kilburn. Judge Thomas, I know you were in the majority in that case. Kilburn is really not applicable. I don't think you can compare a drug case to a firearm case for a few reasons. So in Kilburn, basically what, the court held that just seeing a firearm by itself is not enough for reasonable suspicion to do a Terry stop or a frisk. Firearms and marijuana are not the same thing for a couple of reasons. So first, a firearm in and of itself is not facially incriminating. As the court noted, there's a constitutional right to bear arms. That's not the case with marijuana. With firearms, it's not the firearm itself that's contraband, it's the person in possession of it that makes it contraband. So for instance, if you have a felon in possession of a firearm, it's the person's status as a convicted felon that makes it contraband, not the fact that it's a firearm. And with marijuana, it's different because, Judge Thomas, as you noted, it remains federally illegal in all circumstances to have marijuana.
But isn't the problem, though, that marijuana and hemp are visually indistinguishable according to the stipulation?
They are.
So, I mean, the marijuana that was ultimately found here could have just as well have been a plastic bag of hemp, right? And that would have been lawful?
If it was hemp, sure, it could have been lawful.
Right. Well, I mean, isn't that basically what Kilburn is saying is if it could have been lawful, the handgun there, the marijuana here, if it could have been lawful, the state's got to have more than that to search the person.
Well, what you need to do, and I don't want to jump into the mistake of fact case law because we're not actually dealing with a mistake of fact, but I think it is illustrative, is with the firearm cases, Kilburn, Rigaldo, all the firearm cases, if you just observe a firearm, it's the status of the person is what makes it criminal. If you see a firearm, there is no objective basis for you to reasonably conclude that the person shouldn't possess a firearm just because you see a firearm. With marijuana, it's a little different, even when you factor not being able to distinguish with hemp, because you can still observe it, and the question is not whether you're right or wrong. As I pointed out in Texas versus Brown, the court said you don't have to be right. You have to be reasonable. So if you have, I'm not even sure I would stipulate that it's equally likely to be hemp, but assuming it's a 50-50 shot, I don't know how you could say under those circumstances that an officer smelling it and seeing it, take away the nervous behavior, smelling it and seeing it, how an officer can't reasonably conclude that it's marijuana. And if he ends up turning out to be correct, which in this case he wasn't, he was right, but let's say he did turn out to be incorrect, or he turned out to be incorrect and it turned out to be hemp, instead we'd be having the argument over whether it was a reasonable mistake of fact. But
so let me follow you to the end, though. So that means if 50-50 chance, the officer can arrest the person, can book him, take him to the juvenile detention center here, where he's going to be held for a detention hearing. An adult would go to the jail, would be held for a first appearance. So the state can arrest that person just on a bag of green leafy substance. Is that what you're saying?
Well, I mean, you have the field test as well, which I realize at the time doesn't. I realize,
but you're not arguing field test. I mean, obviously, once you get to the field test, if you have a positive field test, I would think that's pretty clear probable cause at
right.
that point.
Well,
I'm just talking about the visual sighting of the substance.
I still think under the definition of probable cause, yes, that is a fair probability that that's contraband. And I guess to elaborate, because I realize that there was a
Why was hemp made legal? I'm just curious about the background of hemp.
Oh, I'm totally the wrong person to ask about that.
I mean, are people smoking hemp?
I don't know the first thing about it, Judge Thomas.
That's
I'll
probably
be honest.
not in the record.
But I
I thought hemp was made legal because it had other legitimate commercial purposes.
Well, and I assume if we're talking about,
I don't think it was made legal because people wanted to carry it around in a baggie.
Well, and probably not. And one of the things that's that's kind of missing in this case that I found interesting is that, factually speaking, the officer actually testified that when he saw, as this defendant was reaching for his registration and other things, he let him finish, and then he told this defendant what he observed in his pocket. If you're carrying around hemp, that probably would have been a good time to tell the officer, I'm carrying around hemp. And what's interesting is even on that sheriff's office legal bulletin, one of the factors to consider is whether this suspect made any statements about hemp. The fact that he's got an obvious chance to possibly
Right, I mean,
dispel.
an innocent person is going to say, look, I have a medical marijuana card. I have, I also like hemp. I like my medical marijuana and I like my hemp, and that's what I have. And as you said, no, you can't search my vehicle. That's what an innocent person has the right to do, right? That's what he could have done here. Here's my medical marijuana card. This is hemp, and you can't search my car.
With medical marijuana, it's still, we'd still be talking about those. So as the court in Johnson noted, what hasn't changed is marijuana is still illegal in all
What
circumstances.
were the changes in the law since this court's opinion in Johnson versus State?
What changes?
What were the changes in the law since this court's opinion in Johnson versus State?
So there were a couple of changes with the actual medical marijuana statute that obviously aren't applicable because we're not dealing with medical marijuana. And then the elephant in the room is hemp.
What were the
became
changes
legal.
regarding to medical marijuana statute?
For instance, I think at the time, for instance, you couldn't smoke even low THC cannabis in a vehicle. That may have changed since Johnson. Again, I don't know that it really affects this case.
But one of the changes is you can smoke medical marijuana, is that correct?
I don't know if I would go that far because there is, and I don't know if I have the statute in front of me, but for the statute that defines what medical use is, I think it still says it's not acceptable medical use to be smoking it in a vehicle. That part, I don't think that's actually changed.
I understand how you're trying to distinguish Kilburn and our other handgun cases. How do you distinguish Smith and the other baggie of pills cases? Because this seems very similar to that.
So I think a lot of what I argue about the firearm is going to apply to a pill. So by and large, like take Xanax, for example. Xanax on its own is not contraband. What would make Xanax contraband is somebody who doesn't have a prescription for Xanax, who possesses it. So if you see Xanax or substitute whatever other pill you want, you still would have to be able to have something to draw a conclusion about the person that's in possession of it. Again, with marijuana, that's completely irrelevant because it's illegal federally under all circumstances. I think what this is more akin to, and again, I can certainly follow up with supplemental authorities, there is a long line of cases dealing with officers seeing substances in a person's mouth, specifically almost all of them deal with crack cocaine, and the officer seeing, for instance, a white substance, and I have some cases actually on that. But basically, the common theme of all of them is an officer will see what looks like crack cocaine in someone's mouth, order them to spit it out, and then the question being whether they had probable cause to seize the contraband based on only seeing a white substance, and the Fourth District actually went en banc to resolve this issue and said even though the officer doesn't know with certainty that it's crack cocaine, and even though an officer actually acknowledged that it could have been gum, it could have been mint, it could have been any number of things.
Counsel, specifically as a follow-up to Judge Bilbrey's question, if the mere observation of a potentially lawfully possessed pill or firearm is insufficient for reasonable suspicion under the case law, then how can the mere observation of a potentially lawful substance provide probable cause?
Because again, the difference is, and I realize with medical marijuana, in Florida it's legal, federally it remains illegal. So kind of first part to that answer is if we're talking about medical marijuana, it still remains federally illegal for anyone to possess it under any circumstances.
Yeah, that's the amazing thing about that topic is that under federal law, it's a crime to possess marijuana. And a policeman has probable cause to arrest you for possession of marijuana, turn the case over to the United States Attorney's Office as a federal prosecution. I mean, Florida can say all day long, we want people to be able to smoke marijuana for whatever reason is put on the constitutional ballot, but it's a crime under federal law.
That's correct, Your Honor. And there is a case out of, it's a federal case out of Colorado that explicitly says a state legislature cannot grant someone an expectation of privacy in activity that Congress has deemed illegal. I don't remember if that was specifically a marijuana case.
Congress has
but-
not yet decided that marijuana should be legal under any circumstance.
That's
In
correct.
fact, it's a fairly dangerous substance under federal law. I don't recall the classification off the top of my head, but it's regulated as a controlled substance.
It's
illegal.
It might be a Schedule 1 or 3.
Yeah,
I
and
think.
it's,
But I see I'm over my time. I'll just conclude briefly by just saying that I'm going to tie this into the reasonable mistake of fact case law and just say, if an officer can make a reasonable mistake of fact, as the Supreme Court has repeatedly held, and we still find probable cause, then I don't see how any court can say that an officer who didn't make a mistake of fact, but if he did, it would be reasonable, how we still don't get to probable cause. And with that, I will conclude my argument and ask that you affirm. Thank you.
Thank you, counsel.
May it please the court. Nervousness is not enough. I'm up here nervous, hands shaking, but that's not probable cause. Even combined with, maybe I have stolen property, maybe I stole this notepad. Is me being up here nervous with a notepad enough for them to arrest me?
we won't search you on the way out, don't worry about it.
I would expect so, Your Honor. So I would argue that nervousness alone is not enough, even when combined with potential for illegality. I would say Kilburn and the pill cases are absolutely applicable. They're all dealing with contraband or potential contraband cases. Sure, Kilburn dealt with unlicensed carrying of a concealed firearm, but maybe the firearm could have been stolen. Then it would be contraband. And hemp is, under federal law, according to the Congress, not a controlled substance. Identical to, basically, marijuana, other than for THC level, but Congress, the federal Congress and the Florida Congress agree, not a controlled substance. May be possessed and owned lawfully. Under the Florida Constitution and the federal Constitution, you can own property unless it's illegal. That's fine. So owning hemp is perfectly legal, and you may use it as appropriate under the statute. And the legislature here did not see fit to prohibit hemp possessors on the retail level from buying a product and using it as they see fit. They can smoke it, they can throw it away, they can do anything they would like with it. So that's just the law that we have from the legislature. As far as reasonable mistake of fact, I would point out that the United States Supreme Court in Hayen gave us an example of what a reasonable mistake of fact is. That is, somebody driving in a high occupancy lane, and the officer sees one person in the lane. Well, they pull the person over, and lo and behold, there's more people in the back sleeping. So there was not that was a reasonable mistake of fact, because the officer, from his perspective, was looking at something that may be a law violation. Probably is a law violation by fair probability. What we have here, by that same example, is an officer seeing an individual driving in a lane, which may or may not be high occupancy. Maybe it is, maybe it isn't. But the officer assumes that it is, without any other facts really indicating that it is indeed, and pulls the person over. That is not a reasonable mistake of fact, Your Honor. That is the officer going on his hunch that there's a law violation when the facts don't indicate one way or the other. And I see that I am going over my time, so if Your Honors have no further questions, I would ask that this court find that the trial court erred and suppression was warranted. Thank you.
And thank you, counsel. This concludes our oral arguments for this morning. We are adjourned.
All rise.